So, welcome. Hopefully I've made you feel welcome already by ignoring you and talking about something else. But for those of you who are joining us on a recording or joining us from this point, this is week 10. This is the, 2 more weeks to go. I guess we'll probably have a few more than 2 of these because I'm usually, well, pretty easily talked into doing some in SWOT-VAC and beyond for those of you who are online. Depending on what you want to do. So my plan for today is the thing that we've touched upon but not really looked upon in any detail in class for this sort of mega topic of the terms or contents of a contract is the parole evidence rule, which I think we can deal with as a discrete topic. So I put together some slides to talk about that, and I have just realised that at the time of me talking to you, those slides are not in Canvas. At least I don't think they are. But for those of you listening on a recording, they will be by the time this recording goes out. So I'm happy to walk you through that. But before I do, as always, is there any particular question, concern, frustration, anything you would like me to focus on in particular? Silence is golden, as always. Unmute and speak up if I'm not making sense, or even if I am making sense but you have a question or a comment. For the first time in weeks, I actually feel almost human today. So I'll probably keep going unless you shout out loud. So with no further ado, I will share my screen. And we're going to talk about the parole evidence rule. So not on Canvas yet, although I shouldn't have written that there for the recording because they will be on Canvas by the time this recording comes out. You might remember this kind of map that I made at the beginning of these 3 topics, a kind of overview of everything that we're doing. Sorry, that was not meant to go up first. Sorry, I'm just going to grab a pen because I'm in the mood for drawing today. I'll make it a red pen because I'm marking papers and that's the colour I look at the most. So again, you'll remember the first 7, 8 weeks or so, we were basically looking at the question of whether a contract existed. So firstly, whether the formation elements were there, and then secondly, whether or not there was any vitiating factor which might affect the vitiation I've written there. I'm not sure that that's a word. Any word could be verbed. Any vitiating factor that might affect the enforceability of that contract. So things like capacity or formality. But once we've got through that, the next part and the last 3 weeks of our course are really about the question of what are the terms of the contract. So we spent roughly a week looking at express terms. So the representations that the parties make to each other, which could either induce a contract or become the terms of the contract. And we looked at ways of working out which of those things become the terms of the contract. So ranging from things that are said to things that are written down, including formal documentation, but also signs, tickets, and the like. And then last week, we started to look at, it's actually fitting over here. Sorry, I'm just wondering where's my, well, no, it's not going to take us there because normally I do this in this room. Last week, we looked at implied terms. So other sources of terms when the parties either haven't expressed a particular term or the law requires the inclusion of a kind of term, particularly statute. But what sort of sits, and where we will go next in week 11 is around how we read those terms, a little bit more around the reading of the terms, and we'll do that in particular by looking at a particular class of terms, so limiting terms and disclaimers. But sitting as a kind of bridge between the express terms and how we understand express terms is this rule that I want to concentrate on today, the parole evidence rule. So we've spoken about it a couple of times. Basically what the rule says is that if a contract has been reduced to writing and is complete on the face of it, so it looks like it's a complete contract, then extrinsic, so this term here, extrinsic just means extra or outside, sort of somewhere in between there. Extrinsic evidence is not allowed to, and this is important, add to, vary, or contradict the terms of the written document. So the rule is not that, and look, and the shorthand, and I've said it myself many times, if you've got a written document and you've got a verbal term, then the written document trumps the verbal term. But only to the extent that that would add to, vary, or contradict the written document, if we're going to be precise about it. So if you've got something in writing, we won't listen to any evidence that adds to, varies, or contradicts those terms. So here from Justice Innes in Mercantile Bank of Sydney and Taylor, where a contract is reduced to writing, where the contract appears in the writing to be entire. So in other words, we've got no reason to think that there were additional terms that need to be considered. It's presumed that the writing contains all of the terms and evidence will not be admitted of any previous or contemporaneous agreement which would have the effect of adding to or varying in any way. So again, another couple of definitions here, but ultimately we're going to ask this question each time. Is there a written agreement? The parole evidence rule only applies to contracts that are wholly in writing. So if there is a written agreement, we need to ask ourselves, is that written agreement the complete record of the parties' intentions? If it is, then the parole evidence rule will operate to prevent that additional evidence being given to, and the words are here, add to, vary, or contradict. So we won't be able to get additional evidence in relation to that. And it will also limit the type of additional evidence that we get from parties to explain what the document itself means. If on the face of it, the agreement is not an entire agreement, so I'm using agreement as a noun in that sense, so the written document doesn't on the face of it appear to be the full agreement, then statements that were made during negotiations can form part of the contract. It'll be a partly written, partly oral contract, and the parole evidence rule won't apply. Or to the extent that it does, we will be looking at what order statements were made in. And we talked about that a little bit last week when we were, I guess technically it was last week. We talked about it in the most recent on face-to-face class when we were talking about Equiscorp. I think that's how you say the name. And Glengallen is the other party to that matter, where there was some negotiations, and then there was a written document that superseded those negotiations and ended up with different terms. The parties then tried to argue, the borrower then tried to argue that those negotiations should be brought in as part of the agreement. And the court said, well, no, you've got a written document that is different from that, which was entered into later. That represents the concluded negotiations. Some things that were said and done earlier than that were superseded by that written document, and we don't want to see that evidence. Again, these are really wordy slides, which possibly is why they weren't in Canvas, actually, if I'm going to be perfectly honest. I suspect that I was thinking I'll go and put some pictures and diagrams and make them a bit less wordy before I speak to them, and I didn't quite get that far, so we'll see how we go. So this longish quote here is from Justice Kirby in a 1994 case, B&B Constructions, and Cheeseman and Associates. If the written language of the agreement has a plain meaning, evidence will not be admissible to contradict that meaning. The purpose of this rule, and he's talking about the parole evidence rule, which is of great antiquity in our legal system, is by no means irrational. It is to hold parties to bargains reduced to writing which are unambiguously expressed. There's a link here, naturally enough, to the rule of the construction of unambiguous statutory language. If the purpose of that language is clear, the duty of the court is to give effect to the intention of Parliament derived from the unambiguous language. The social purpose secured by such rules is to discourage litigation with time-consuming, costly, and I can never say that word, dilatory exploration of detailed facts and the resolution of conflicts of the recollection and testimony. So in other words, there is an efficiency in, if we have a written document that is clear, plain, unambiguous, then there is an efficiency in the courts actually saying, well, we're not going to try and understand that in a different way. We're not going to waste the court's time and the public purse by arguing that if it says it's red, it looks like it's red, then we're not going to argue that it might be purple or maroon or muddy brown. It says it's red, it looks like red, and we've got no reason to bring in any other evidence. We can make sense of it on its face the way that it is. But notwithstanding that, the approach ultimately is narrower in some places. So Lord Wilberforce in this, Wilberforce I should say, in Reardon, Smith Line and Hanson Tangen, 1976 UK case. In a commercial contract, it's certainly right that a court should know the commercial purpose of the contract. And this in turn presupposes knowledge of the genesis of the transaction, the background, the context, the market in which the parties are operating. And Justice Mason too has said the true rule is that evidence surrounding circumstances is admissible to assist in the interpretation of the contract if the language is ambiguous or susceptible to more than one meaning. And I think this is consistent with what Justice Kirby has said earlier. This English approach is probably broader than we need unless the language is ambiguous or we can read it in more than one way. So what is extrinsic evidence? Anything that exists or occurs apart from the document that appears to be apart from the document that appears to be the complete record of agreement, which might include oral statements, written statements, or other conduct. So it could actually include contextual information, like if we're just looking at the writing on a receipt or a ticket, we will also, extrinsic evidence might be brought in relation to whether there was clear signage. So if you think about Shoe Lane parking and Thornton, or Thornton and Shoe Lane parking, can't remember what way around the party names go at the moment. You'll remember in that case there was a ticket that said, now it didn't appear on its face to be a complete record of agreement. It said parking is subject to the terms on the signs. Mr. Thornton didn't look at the back of the ticket anyway, and the signs weren't obvious. So extrinsic evidence was brought as to how the signs were set up and what they said. But again, because that didn't purport to be the entire agreement, there was no argument in that case that we needed to think about the parole evidence rule. I'm just using it as an example. So there are two limbs to the rule. When you think about it, this should make sense. The first limb is that the rule prevents extrinsic evidence being given to add to, vary, or contradict the terms as they appear in the written document. So we can't bring evidence that of other conduct or other documents, extrinsic evidence that does these things. But it also limits the evidence that can be given to explain the meaning. So contextual information that would explain a particular understanding that the parties had of how a particular term or document worked may well be limited by this rule when the document itself appears on its face to be entire. So in order to think about this, we need to think or understand about, we need to have an approach to understanding about whether the contract itself is or is not wholly in writing. So we start that effectively by looking at the document itself. Sometimes you will find an entire agreement, sometimes they're called merger clauses, in the document itself. So that would be a provision that says something like this. This agreement constitutes the entire agreement between the parties and supersedes all communications, negotiations, arrangements and agreements, whether oral or written, between the parties with respect to the subject matter of this agreement. We're going to look at tomorrow night at a case that involved one of these clauses and unpick it in a little bit more detail. But this is quite a standard thing. So if the document itself says everything that's relevant to this agreement is in this piece of paper or these pages, the parties agree that anything, this supersedes their negotiation, so anything that's not included, we didn't agree, it's pretty clear that the parties intended that the document is the entire agreement, and as a consequence, the parole evidence rule will apply. Alternatively, the court has two approaches to working this out. There's a strict approach. So if a written document appears on its face to be a complete record, extrinsic evidence will just not be allowed. Or a broader approach where the court itself will focus on ascertaining the presumed intentions of the parties by admitting the evidence to consider whether the written document itself was intended to be an exclusive record or not. If that evidence demonstrates that it was supposed to be an exclusive record, then no extrinsic evidence can be brought to add to, vary or contradict the terms. But if that evidence shows that it wasn't intended to be the entire agreement, that there was some contextual information or some negotiations or even another website or something that the parties would point to, then then extrinsic evidence can be brought and the parole evidence rule won't apply. So what are the exceptions to the rule? Don't you hate it? This is a constant about this subject, isn't it? We work out what the rule is and we learn how to understand it by looking at the exceptions to it. If you can prove that a contract is only partly written, so it's partly written or also partly oral, then the rule doesn't apply, because we need extrinsic evidence to be brought other than just the written document to demonstrate what the partly oral elements of the agreement are. You can prove that some kind of representation was made that gives rise to what is called a collateral contract, which we'll talk about in a moment. And then this one that you all love to hate, you can prove an estoppel. So in other words, you can, if there is a basis in equity for doing so, you can stop a party from claiming that there is an entire agreement and therefore the parole evidence rule applies. And that additional evidence would be let in based on the inequity that would be caused if you did not allow that additional evidence. And you can see there's a bit of a chicken and egg here, can't you? That the parties, in order to work out whether the rule applies, there will be times when that broad approach is needed, where a court will need to look at broader evidence to work out whether it can look at broader evidence. So, you know, it's kind of, this is why I'm not a litigator. That stuff would just annoy me way too much. So we spoke on Monday about equiscorp. Do we think that's how we say it? Equiscorp, two U's. Like, what words have two U's? I bet there's plenty in Dutch, aren't there, with two U's? She's nodding. Okay, I'm going to make you the boss of how to say equiscorp. Glengallen I can say. I'm sure that's the name of an Irish whiskey. I know that one. So in that case, you remember that when we spoke about it briefly, there were some borrowers. They didn't want to pay money back. There were some negotiations to change the loan agreement. So in that case, the court said, okay, it might be partly written, it might be partly written and partly oral, but a subsequent written contract will supersede a prior oral agreement. The court gave effect to the objective manifestations of the intentions. So if the parties enter into a formal agreement, then there is an objective basis for, reasonably assuming that that was where their negotiations landed, that that's what they actually agreed. So now we get to this tricky idea of a collateral contract. So a collateral contract is a promise that's made in addition to, but independent of, a main contract, and entry into that main contract constitutes consideration for the collateral contract. Now, I think I was talking about this. Did I talk a little bit about Shanklin Pier in Monday's class? Because I think Shanklin Pier is I thought I did, but doesn't mean that I did. I just might have been thinking about it. I think the Shanklin Pier case, unfortunately, it's not easy to find the case, and it's not actually in your textbook. If you're looking online, there's a good summary of it in the GRAW Australian Contract Law text. Although there was for about, I think that that's got some fairly recent additions that I haven't looked at. The version that I have of that is about 5 or 6 years old now. So in in Shanklin Pier and Dettel, what happened was that Shanklin, unsurprisingly, owned a pier, and they needed to get this pier painted. So Dettel made paint. And so Dettel came to them and advertised its paint as being particularly good for marine use. So Shanklin Pier said, okay, that looks like a good thing. And it put out a tender to get someone to paint their pier. And in the tender, they specified that you need to come, you need to paint, and you paint it in this colour using this product. So a set of painters, I don't know who they were or what they were called, they successfully tendered to paint Shanklin's Pier and use the Dettel product. But it turned out that the product was wholly unsuitable. And within quite a short period of time, it started to, stop repelling barnacles, peel off into the water, do whatever a wholly unsuitable paint for a pier might do. And so the question became whether or not Shanklin could sue Dettel. And if it did, on what basis would it do it? So I know where I mentioned this case. It's in the context of privity. And one of the workarounds for privity is a collateral contract. So in effect, Shanklin didn't have a direct contract with Dettel, but what it did have was a collateral contract. Dettel had made undertakings to Shanklin about the benefits of this paint, and in reliance on those undertakings, Shanklin had specified that paint in its tender, which means a third party entered into a contract with Dettel to buy that paint. So what we had is a collateral contract between Shanklin and Dettel. So the collateral contract related to the promises that were made by Dettel to Shanklin that were independent of the main contract. So the main contract here was the contract between Dettel and the people who painted the pier. That is way harder to say than it should be on a Sunday night, let me tell you. And the consideration of the collateral contract, or for the collateral contract, was the promise that was made to Shanklin. So collateral contracts need to involve a promise, not just a representation. So it needs to be something more than a promise. It needs to be made to induce entry into the main contract. So by promising that its paint was suitable for a pier, it induced the detail that ended up with Dettel and the paint the peer painters entering into a contract, and the terms of the collateral contract cannot be inconsistent with the terms of the main contract. And clearly they weren't inconsistent. So I give you that example because the example that we use in the textbook to describe it is an example where no collateral contract was found. And that's the Hoyt and Spencer case. So basically in Hoyt and Spencer, Spencer entered into a written agreement with Hoyt to lease part of its effectively shopping centre type premises. In 1919, I don't think they had shopping centres like we imagine them to be now, but effectively we've got a main landlord and part of a complex it wants to lease out to as a movie theatre. So that we've got somebody who owns the building, then we've got a key landlord and then some sub-tenancies. So Hoyt's was going to be a sub-tenant. The lease between the main landlord and Hoyt's contained a proviso in writing. It said, provided always that Spencer, oh actually, sorry, I've got it the wrong way around. It was Hoyt's. Hoyt's is the main landlord, Spencer is the subtenant. So I don't even know what he did. Let's say he was the lolly bar. He's got a little shop inside the theatre. Hoyt's is renting the whole place for a movie theatre and subleasing an area to be for lolly bars and chop tops. I don't know if that's true. It's probably not, but it's just easier for me to think about it if I can put some context into it. So Spencer has a look at the lease and it says, provided always that Spencer may at any time during the currency of the term, oh God, I have done it the right way around the first time. Clearly when my computer crashes, I lose it. Okay, let's go back. Shopping centre, cinema. Shopping centre owner can at any time, shopping centre head lessor, I should say, can at any time terminate the lease by giving the lessee, Hoyt's, at least 4 weeks' notice in writing of his intention to do so. So Hoyt's asked, well, what's that actually all about? And they were told, don't worry about it. I'll only exercise that right if the head lessor tells me I have to. So, yeah, I really need to draw this out, even for myself. We've got an owner who owns to a head lessor, then we've got subtenants, and then we've got another layer. So this is Hoyt's and this is Spencer. So Spencer is saying, I'm only going to kick you out on 4 weeks' notice if this head lessor tells me I'm going to leave. Okay? I understand now. I'm just hoping that you guys do. Get rid of all of that. I'm sure it'll muck up my slide otherwise. A little while down the track, surprise, surprise, Spencer says, sorry, Hoyt's, our agreement says I can kick you out on 4 weeks' notice, so here's 4 weeks' notice that I'm going to require that to happen. They're saying, well, that's not fair because you said you would only do that if the head lessor said that you had to do it, and there's no evidence that the head lessor said that you had to do it here. So the issue became in the case is whether there was a collateral contract. In other words, was that promise that a particular term would only be exercised if the head lessor made them do it, could that be a binding promise, an extra contract that sat outside the written lease that they already had? So the parole evidence rule doesn't apply. So there's an exception to the parole evidence rule if we have a collateral contract that involves the promise, not just a mere representation. So here we had a promise that we'll only kick you out, we'll only exercise our rights under that clause in a particular circumstance. It needed to be made to induce entry into the main contract. I think we can argue that that might well be the case here because Hoyt's specifically asked about that question. It's a bit like, remember Vanden Eschet and Chapel, the one where the question was asked about the white ants just at the time of signing the lease. And then thirdly, the terms must not be inconsistent with the terms of the main contract. So ultimately that was the issue that made this one fall over. because saying we will only exercise a right we have in a particular circumstance is inconsistent with a contract that just provides that blanket right. So the promise in the alleged collateral contract impairs the contractual rights in the main contract. But for the additional promises alleged in the collateral contract, the landlord would have the power to do exactly what they did. So Hoyt's case was that by the collateral contract, the power to terminate was cut down almost to the point of rendering it nugatory. So nugatory in this context means null, void. It's effectively a form of illusory promise. So the collateral contract is inconsistent with the main contract, so accordingly not legally enforceable. That's why I spent all that time talking about Shanklin, because I think it's to define a collateral contract by reference to a contract that ultimately wasn't found to be an enforceable collateral contract is just too confusing. Of course, particularly when I'm getting the parties back to front, that's particularly unhelpful, I guess. Any questions from any of you there? You clear enough? Or not quite clear enough to have a question yet? Please come back to me with them if you do. The next area which we need to think about is when will an estoppel arise? So there's a few different examples of this. Sale and Romanus is a fairly recent New South Wales Court of Appeal case. It's in your textbook. That was a case that involved some brothers, actually. So Romanus contracted to buy land from Sale on the assumption that Sale's brother, who owned the land next door, would enter into a joint venture to develop both of the properties. But before the written contract was signed, Sale told Romanus that if the joint venture did not go ahead, before it was signed, he told Romanus that he could get his money back. It didn't go ahead and Romanus terminated the contract. There it was found that there was a promissory estoppel which prevented Sale from enforcing the contract. The extrinsic evidence required to establish the estoppel wasn't excluded by the rule. So in other words, a party entered into an agreement based on a promise and the other party was stopped from relying on the rule that would have avoided that promise. Another good example here is if proving an estoppel is Whitted and the State Bank of New South Wales. This is a classic STD case, sexually transmitted debt. So the phrase we tend to use for mothers and spouses, they tend to be women who suffer from sexually transmitted debt. Their mothers or women whose usually husbands or sons have got them to sign something that means that they've ended up in debt that they didn't understand or didn't expect. So in this case, Mr. Whitted liked to speculate on the stock exchange, and Mr. and Mrs. Whitted were joint tenants of their family home. And so joint tenants, you won't have done property yet. What that effectively means, if you own a property or any kind of property, you can own it as tenants in common, which means each of the owners has a specified percentage ownership in the property. So, they could have owned as tenants in common 50-50. But as joint tenants, that means both of them own the whole of the property together. And it's quite common for spouses to own property as joint tenants, and then that means the first of them to die, the other one owns everything. They're not at risk that their children inherit and the spouse is left as a co-owner with children or things like that. So it's quite a common way for people to own property. And the Whitteds owned their property as tenants in common. It was worth about $600,000, which is quite a lot of money back in 1991. I think it's quite a lot of money now, personally, but it's certainly in 1991. So Mr. Whitted wanted to borrow some money to trade on the stock exchange. And the bank agreed to lend him $100,000, but required security for the loan, which meant that Mrs. Whitted had to agree as well. So they asked her if she would agree to allow the house to be security for a loan to her husband. And she said, yeah, I can agree to that, but he needs to give me a second mortgage. So I want some protection here. She clearly didn't trust him very much. And you need to promise me that you won't advance him more than $100,000. So the total exposure is that. So because effectively, if the bank has security and the loan isn't paid, then the bank can exercise its security, which essentially is, the language is foreclose on the mortgage. They can then sell the property. They then recover the amounts that are owed to them, and then any other creditors stand in line. So that would mean that Mrs. Whitted would be the next in line to get the balance of the property if that happened. Okay, so that's what she had asked for. So for a long time, the bank lent Mr. Whitted money within the confines of that limit, and they saw that as being the appropriate amount of money because there were some oral assurances being given. But then there were some foreign exchange transactions which ended up several $100,000. So, oh, sorry. So there's our security then. So several $100,000. The bank then went to foreclose and said, basically, when everything's sold, you'll have about $50,000 left over for your second mortgage. And not surprisingly, Mrs. Whitted was not happy with that scenario. So what happened? The bank ultimately was stopped based on a clear and convincing proof regarding the pre-contractual negotiation. There was an assumption that they wouldn't enforce beyond $100,000. There was reliance on the undertaking that they would not advance him more than $100,000. There was detriment that anything beyond the $100,000 would have belonged to her, and because they advanced more, their technical right would mean that she suffered that detriment, and it would be unconscionable for the bank to resile from the assumption that was induced. I'm getting better, I promise, and you can't catch it from there. So ultimately the court found that there was an estoppel which prevented the bank from recovering more than the amount which the parties understood to be secured by the mortgage. So in the end, she still had to sell her house, but the bank was only able to recover the first $100,000 as a consequence of that estoppel. So that's pretty much all I've got to say about the first limb of the rule. Oh, wow, we're running out of time already. I just want to pause, see if we've got any questions, concerns, frustrations. We've already had jokes, so. Second half of the rule, or second limb of the rule. So this is the part where the rule itself will limit evidence being given by parties to explain the meaning of the terms in a written contract. The scope of this rule is that evidence of surrounding circumstances to a written contract will be admissible for the purpose of assisting in the interpretation of the contract, and only if the language is ambiguous or susceptible to more than one reading. And the key case here is Cadelpha, which we can talk about here. For your purposes, probably the most relevant parts of Cadelpha are spoken about in the extract in your casebook, which deals with toll. So Alpha Farm and toll and Alpha Farm. So in that case, Justice Mason said the true rule is that evidence surrounding the circumstances for the making of the contract is admissible to assist in the interpretation of the contract if, again, the language is ambiguous or susceptible to more than one meaning. So it's ultimately, this is a somewhat narrower approach than we're seeing in the UK. The words in the contract need to be given their plain and ordinary meaning, and the recourse to evidence of surrounding circumstances is only necessary if there is an ambiguity. So the next couple of slides I've got are really just summarising some of the discussions about this. So cases include this Royal Botanic Gardens and Domain Trust and South Sydney Council case, where we've got basically the full court of the High Court, Chief Justice Gleeson, and then Justices Gaudron, McHugh, Gummow and Hayne. Again, this is summarised. It's in your case book at 1330. Evidence of surrounding circumstances admissible to assist in the interpretation of a written contract, again, if it's susceptible to more than one meaning. So in that particular case, the phrase that the court was grappling with was this question, the phrase that said, the trustees may have regard to additional costs and expenses. Additional to what costs and expenses there were. There was an ambiguity as to which of the alternatives was intended. So we can go and look at the extrinsic circumstance to see what the thinking of the parties was as they put that term in place. Another one, McDonald and Longbottom, that's a case where the words in the document referred to your wool, and the court needed to work out, did your wool mean only wool that came from your sheep, or did it mean any wool that you owned at the relevant time? So could it be stuff that was included in your barn, for example? Other cases included things like Appleby and Purcell, where there was a lease of rural land and the lessors were responsible for pushing and stacking the timber on the land. Extrinsic evidence of what the words pushing and stacking in the context of clearing timber meant needed to be brought in so that you could understand. Even though the words push and stack on their own, I think we can all understand what those two words mean, but in the context of clearing rural land, we could bring in to resolve the ambiguity, bring in evidence. What other cases have we got here? Burns and Kendall. A contract means what a reasonable person having all the background knowledge of the surrounding circumstances available to the parties would have understood them to be, using the language in the contract to mean. So, sorry, I have a feeling some words might be missing here, but effectively what Justices Hayden and Crennan are saying there is we use an objective test. So the words will have a plain, ordinary meaning in the context of the people having the knowledge, what a reasonable person having the same knowledge and experience as the people entering into the contract would have. So we're still using an objective test. Oh, I really just want to hide myself on this camera. Every time I look at you guys, I just see my chin. It's not pleasant. Partly written and partly oral contracts. Again, the rule doesn't apply when we have, the parole evidence rule applies when we have an agreement which on its face appears to be entirely in writing. So if we still might need to bring in extrinsic evidence to demonstrate that it is reasonable to understand that the contract is not an entire agreement. And a good example of where that might have happened is Botanic and Chapel, which is the white ant case that we spoke about a couple of weeks ago. Oh, that's everything I want to talk about. I'm just going to see if I can stop that and bring my, I'm just going to have another go at turning my other camera on. No, it's just not going to do it. Might be my camera that's crashing my computer actually now I think about it. It's quite old. Questions, concerns, frustrations? I don't really like to use the tutes for so much content, but it's hard when we've only allocated 2-hour classes to get through all of the content otherwise. So, but we're on the home stretch. We really are.
Kath, at the start earlier on, I didn't want to interrupt. You mentioned, I'll struggle to say, contemporaneous agreement. Can you tell me what that is?
So an agreement made at the same time.
Okay, thank you.
Yeah, the language can get a bit woolly. And I recognise the irony there that we're talking about interpreting language and we're using woolly language to talk about how to interpret language. And look, the reality is in this course, we don't have time to go through all of the interpretation rules. And I know in intro, you do a bit looking particularly at statutory interpretation, and the common law approach is not terribly different. There are some really good resources around. And again, in the exam, you won't be asked anything that we don't, well, actually you might be asked things we haven't directly covered in the course, because clearly we're trying to work out how you think, but in relation, you won't be asked to interpret in a way that we haven't dealt with in class. From, sorry, I'm just having a look at my bookcase because I just want to show you one thing. From a practice point of view, I mentioned this book in class the other day. I'm just going to work out where it is. This, for my money, is probably the best interpretation text. It's eye-wateringly expensive. You know, I think this little volume here set me back about $800. Like, it's ridiculous. And actually, and to be fair, it was a gift. So that's what it would have set me back. I don't believe it's available online. But I do think that I'm pretty sure the library have a copy, and it really breaks down interpretation. You don't need anything at this level as students, but I just think it's worth pointing out. So Lewison is a QC in the UK and wrote Lewison interpretation of contracts because it was the UK. They didn't need to say anything else. And then Gordon Hughes is QC here, and they've written an Australian version together, and it really is exceptionally good. So worth having a look at. Any other questions or concerns? How are you guys feeling about course generally? You feel like you're keeping up and on top of things? Keeping up? No? Sorry, I didn't mean to upset you. Look, it's a little bit hard. It's always hard at this time of year, right? Everybody's tired. You've had back-to-back assessments. There's a whole heap going on. And then suddenly we've got, 2 more classes before it's over. So it can feel very overwhelming. I completely get that. But we effectively will finish the new content tomorrow in class. And then we'll spend a whole week in revision. And I've got some pretty fun activities for that. I'll get some information out to you from next week around what your exam's going to look like in broad terms. And so you've got some understanding about that. And hopefully by our class next, not tomorrow, but Monday week, I'll also be able to give you some overview feedback on the assignments. I'm not quite sure how that's going to happen because I've been so sick for the last week that I barely marked any of them, but it's all right. I've blocked out time to make sure that happens next week. So anyway, we'll get there between us. All right, well, unless there's anything more from any of you, we got a new oven and hopefully my husband and son are cooking something in it. I'm not quite sure what I can share with you about what we're eating today. I know that's sort of a thing I do. If any of you are having anything good for dinner, I'd like to hear what it is. But
my dinner's coming from 7-Eleven, so you're up on me. Doing well.
I went to a barbecue this afternoon to celebrate. A friend of mine ran around Lake Tahoe, so 200 miles. Like nobody actually made him do it. He hadn't stolen anything. Under a hole, and everybody else at the barbecue, I think, other than me and his wife, had done this run. Like ridiculous, insane thing. But my friend and his wife are Vietnamese, so the best food, best food all day. So I don't actually care whether I don't have dinner or not because I ate really well. So I'm very food motivated. Does that show? All right, guys.
Thank you very much.
seriously, the parole evidence stuff, I know there's a lot of content there. I'll get those slides up very shortly. It's not critical to know, but it sits underneath. So when you're thinking about, so your exam will involve, you will get a sample contract before the exam, and you'll get a number of scenarios that ask you about things in relation to that contract. A bit like that most recent assignment, okay? Only different. So when we're looking at that, you know, understanding how a written agreement might supersede a verbal conversation will be an important thing for you to know. And thinking about collateral contracts or estoppels in that sense will also be relevant. But at the same time, it's not something you're going to be asked to do backflips about. So yeah, just, you know it, understand it. You need it to be lawyers, but don't let it stress you. And I just wanted to focus on it particularly because I just felt like we'd skimmed over it a bit in class.
Okay.
Awesome. Okay, no problem, Scott. I'm assuming that's Scott. I will get your name right one day. And Scott sent me a message. That's all good. PP, I'd love to know who you are, but it's been a pleasure having you. The rest of it, you've got beautiful faces. Thank you for sharing them.
Thank you, Kath.
Thank you, Kath. Have a good evening.
Thank you, you
Bye-bye.
too. Say hi to your kids for me, Sigrid.
Will do.
Bye.